Welcome back. You pay a premium, so does that mean that you don't have to sit through commercials? Well, that may not be the case. A federal judge is dismissing a proposed class action lawsuit over Amazon's decision to begin showing commercials on its Prime Video service unless subscribers pay a $2.99 monthly opt-out fee. Subscribers who pay a $139 a year fee for Prime Video said that Amazon had led them to believe the service would remain ad-free. They said that the ads amounted to a price increase that breached their subscriber agreements and violated consumer protection laws.
We're joined now by Chief Legal Analyst Khalif Rhodes. Judge said, nope, not so fast. Amazon's good to go. How do you feel about this, Khalif?
As an avid Amazon user, I was watching this, trying to and hoping that it would go another way. But no, all jokes aside, I wouldn't have fallen into that category because I don't pay for mine in the year in advance. I think that I probably need to go back and fix that. But I'm doing it every month, so I don't fit into this category. I wouldn't have fit into that class. For you to be in a class, you have to be similarly situated. And so in this situation, yes, I would have checked the box as an Amazon user, but I would have not checked the box as a one person that subscribed per year, so I wouldn't even have fit into the class. But I think this is kind of like the argument we talked about earlier about grants being issued and then being able to be taken back. This is also, I think, back in the day with the kind of bait and switch where you look at something in the newspaper, you call and they're like, yeah, I'm gonna give you this, but you got to give me 50 other things to be able to qualify for it. I mean, if I've already paid for something on a year basis and the terms are set there, I can guarantee they talk about we have an ability to modify, that these can change at any at our discretion and whenever we want. But the judge said this is a benefit modification. I don't know if I'm buying that. It's a benefit modification to not have commercials. I mean, if I purchase it today and there's no commercials, and then tomorrow you start running commercials, I was anticipating that there would be no commercials. When the whole urge to cut the cord came out, it was get rid of having cable. Get rid of having commercials. You don't want to have to worry about that. So all these streaming services popped out without having commercials. But then they recognized that, wait, that model was very successful financially from an advertising perspective. We need to add commercials. And if you don't want to have commercials, you got to pay for it. And for the folks that have already paid for this year-long service, we'll just, as the judge said, we'll just modify the benefits. I don't know if that's what a modification is. This seems like a different service. If it wasn't a different service, you wouldn't make me pay for it for something additional that I don't want. So I would love to see this appealed just because I don't think that the judge's logical steps to say that this was a benefit as opposed to a new type of service. I think that this was clearly a different service because they're benefiting from that $2.99 opt-out fee that you're paying.
I mean, that's about 36 a year. You multiply that times millions of subscribers. You're in the millions and billions of dollars just so you don't have to watch commercials. Now, I mean, it seems like deceptive pricing laws. So as a subscriber, can I challenge this? Do I just have to take it or leave it? I mean,
this is the venue. And I mean, two parts. Yes, if you don't want to pay for commercials and you don't want to pay the $2.99 opt-out fee, yeah, take it or leave it. You can go to Netflix or someone else. But if you were in this class and you qualified by paying for a year and be a subscriber, I mean, right now it's dead on arrival at the doorsteps of the U.S. District Court judge because they've dismissed it. But they could appeal this right here based on, I think, the process and his thought process is some of these folks that utilize these services will be in a different age bracket than the people that are deciding these cases. Maycase talked about it a couple of times with aging out, and I don't try to be an age discriminatory person, but I think you have to really utilize the services that you are talking about when you're rendering judgment on the services that other folks are asking about. I haven't looked at the numbers, but I would suggest that their demographic that they're targeting isn't folks that are sitting on U.S. courts benches most of the time. And because of that, I would anticipate that they don't recognize that I've had commercials my whole life. So you're worried about commercials. No, I paid for this streaming to not have commercials.
Right. It's not about we don't want commercials. It's I paid for it, right?
Yes.
You know, we get those emails that say, hey, we've updated our terms and services agreement that you agreed to. Is a defense saying like, hey, we kind of laid this out that we can change whatever we want? Or does that go back to your original point that it's a modification that shouldn't be allowed?
I think that's where the question presented will be presented to the court. I think a couple things within there when they talk about prices going up, right? Netflix will take up their prices $1, another $1. You know, gradually you went from $7 to $17. And you didn't think about it. Like, hey, it was allowed, it happened. But when you're talking about the changing the services or things that I'm getting access to, like if you said now you don't get these channels anymore, I think that's pretty clear cut. But if you anticipated that I was getting commercial-free streaming, that's how they advertised it when you first got it. Looking back when Prime and all these folks start first rolling out. Now they don't talk much about it. Why? Because the $2.99 was something that they recognized they could get as an additional income earning opportunity.
Khalif, I do want to ask you, what precedent does this set for other people like Amazon and say Netflix to say, okay, if you're going to let Amazon get away with just this small change in benefits, what can we do?
I mean, it's like the David versus Goliath argument. First, I'd say that the precedent is already here, that if you can't, you're going to look at what the contract says. Every judge is going to say, I'm going to look at the four corners of the document, even though you signed it online. Tell me what the four corners of the document say. In the document, it says that we unilaterally can change, make modifications whenever we want. We're going to stick with the document. But now we have to break down the word. Is it a modification or is it a new service? I'd argue it's a new service, and you're charging me for a new service when I've already paid for the other one. So back to law school, it would say that a contract, an offer, and consideration has closed this agreement. Now, if you want to start a new agreement and make me pay for a different service, I don't mind paying for it after my 1 year has expired, but I don't want to pay for it in the middle of the one that I've already paid for. So yeah, you can make changes, but you can't make changes to something I've already paid for. That's the argument. I think Netflix, all these other folks, if you go up against them, if you don't have a class, if you don't have hundreds of people, it's not going to be successful because it's you versus Goliath.
I mean, David won, right?
You got that one stone. You better have a big stone.
Yeah, really bolder. All right, Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.